कंट्री। बहुत बहुत धन्यवाद आपका समय दिया।
थैंक यू डॉक्टर सस्मित पात्रा जी। माननीय कनक मेदला रविंद्र कुमार जी।
Thank you, sir. This is purely on the subject, sir. Sir, the three new legislations, Bharatiya Nyaya Sanhita, BNS, Bharatiya Nagarika Suraksha Sanhita, BNSS, and Bharatiya Sakshya Bill, BSB. Sir, the reflects a holistic approach to reforming the criminal justice system in India. By embedding transparency, accountability, efficiency, and modernization into the provisions, these laws pave the way for just, responsive, and contemporary legal landscape that can better meet needs and expectations of the Indian society. Before the introduction of these new three bills, the entire gamut of criminal law in India in the past only piecemeal changes have brought into. For instance, Criminal Law Amendment Act 1983 was a direct result of infamous Madura rape case in 1972. Similarly, Criminal Law Amendment Act 2013 was introduced after Nirbhaya case. There are the landmark directions of regarding the arrest related to safeguard given by the Honorable Supreme Court India, D.K. Basu and State of West Bengal were also formally recognized by amending CRPC. But this time, all the three criminal major laws in their entity are sought to be replaced. A large emphasis has been placed upon seamless integration of the used digital technologies in criminal judicial system. The courts have also removed references to several archaic and dated provisions. Sir, there are positive changes in Bharatiya Nyaya Sanhita. In an attempt to make criminal laws gender neutrality, the meaning of the term gender has been changed as Section 2, subclass 9 of BNS now defines gender as the pronoun he, and it derived or used as any person, whether male or female or transgender. Sir, under IPC, potential victim of kidnapping can be a minor girl or a boy under 18 years and 16 years of age respectively. Decoding the intent of legislature, it appears that the discrepancy in the age of girls and boys was on account of the socio-political setup of the country in the 19th century. However, BNS addresses the discrepancy and raises the age of victim kidnapping 18 years, irrespective of their gender. Although BNS retains the marital rape exemption clause, in the light of judicial pronouncement of Independent Thought versus Union of India, 2017-10 SEC 800, the age bar under clause has finally raised to 18 years in the text of law, as well as amending exception 2, clause 63 of BNS. There has been considerable shift in the approach of the Indian criminal justice system for the retributive system of punishment to the reformative one, by including community service as a new kind of punishment for petty offences. BNS also confers the changed approach. Community service means any service rendered for the betterment of the community without any compensation, either voluntarily or compulsorily. As a punitive measure, the ambit of community service still needs to be determined. This gives birth to need a system of a popularized scheme as well as monitor and supervisor compliance. The possible mechanism could be setting up district-level community service committees or assigning tasks to the existing probation officers. However, the new code remains silent on the specific modalities of the same, which may leave scope for arbitrariness. Sir, BNS show cases overall increment in punishment exceptionally in the amount of fine. For instance, the amount of fine voluntarily causing hurt can be up to 10,000 rupees, which under IPC was more than 1,000 rupees. This was much needed reform since penalty prescribed under IPC turned redundant as it served little purpose. Sir, another positive variation witnessed in the BNS in the use of phrase person with mental illness rather than insensitive word like lunatic, idiot, etc. The term mental illness means substantial disorder of thinking. Sir, the debate whether a right of life includes right to die seems to have come to an end with the BNS not criminalizing the attempt to commit suicide. Section 309 of IPC, which criminalizes the same with up to 1 year imprisonment, has not been retained in BNS. Despite the constitutional validity of Section 309 being upheld by 5 judges bench of the Supreme Court in Jain Kaur versus the state of Punjab in 1996 AAR 946. However, the same provision currently does not have penalizing impact in the current times by virtue of Section 115 subclause 1 of Mental Health Act, Healthcare Act 2017. It additionally casts duty on the appropriate government to provide care, treatment, rehabilitation of the person. Sir, one of the biggest complaints which people have had with IPC for 163 years is that the definition of murder and culpable homicide not amount to murder is ambiguous. This often leads to conflicting and confusing interpretations as the demarcation between the two is not clear. The new law still remains the same definition for both these clauses. As per the landmark verdict given by the Honorable Supreme Court of India in Navatej Singh Sohar versus Orissa and Union of India AR 2018 SC, homosexual relationship as per 377. Section 377 should decriminalized only to the extent of the decriminalized consensual sexual intercourse between the adults. So, although it was widely recommended that the version of the erstwhile Section 377 should be retained if even the new draft has failed to do the same. This is quite problematic, as now there is no recourse for sexual offences of rape against men or transgenders in the penal code. Similarly, another recommendation that the offence of adultery should be retained in the gender-neutral form was ignored in this bill. While attempt to suicide has been decriminalized, the offence has not totally been discarded, since a version, if it is criminalized under Section 224 of the BNS, where the intention is to compel or restrain public servant from discharging his official duties. Sir, BNS has introduced a new section, a new offence as per Section 69, wherever the sexual intercourse by deceitful means is criminalized. Under the IPC, consent obtained by false promise to marry is not a valid consent as per Section 90 of the Code. This new provision is intending to cover instances where there is a sexual intercourse pursuant to a false promise to marry a woman. Sir, BNS by Section 102 also restored the essence of Section 303 of IPC, which prescribed a mandatory death sentence who commits murder while serving a life of sentence. This section was held unconstitutional by the Supreme Court as per verdict in the landmark case of Mithu Singh versus State of Punjab, AAR 1983, Supreme Court 473. It has been claimed by the drafters of the controversial provision regarding the offence of sedition of IPC under Section 124A has finally been removed. However, the BNS introduces new provision as per Section 150, which criminalizes act endangering sovereignty, unity, integrity of India. It can be observed that the essence of the offence sedition has still been retained under the new law also. BNS also criminalizes organized crimes and terrorist acts as per Section 109 and 111 respectively, which was not the case.
Conclude, please.
Sir,
already your time is over. 1 minute, please conclude.
Sir, being a practicing lawyer, may
I know.
Minutes,
so please,
sir.
1 minute, please conclude.
So, because it is a subject related to our purpose.
Yes. Please, 1 minute.
Sir, okay, sir. Only one act I covered. There are two acts. I will try to conclude with you. Sir, with regard to the Bharatiya Nagarik Samrakshaka Sanhiti. Sir, as per specific section now finally defines audio, video, electronic means as per Section 2.1 of BNSS. Similarly, 2.1F of the new code elaborates the electronic communication. So the BNS has contemplated multiple references in two phrases. 105, it provides recording, search and seizure of audio, video, electronic means. Even FIR can be registered. Such digital means now this legal recognition. BNS removes all several anarchic technologies. I'll conclude.
Please conclude.
The provisions are now better structured so that pursuit of the justice not defeated on account of delay of the proceedings. In addition to Section 356 of Sanhita, which provides
conclude.
Speed, I conclude, sir.
Please.
Trial mechanism of conduct a trial absence of proclaimed offender. Sir, coming to the, after trial culminates, even judgments have to be pronounced within 45 days of online. But in the present circumstances, even though judgment pronounced within 45 days, appeals are pending. 15 to 20 years are before the court.
Please conclude.
Even Delhi, concluding, sir. Yes. In Delhi, I mean, there are about 188 courts or no buildings. No courts are functioning there.
Thank you, sir.
Finally, sir, I request.
Thank you.
I wanted to congratulate